Welcome to the Probate Nation. This show is part 3 of our 3-part series covering the typical issues discussed in the initial probate consultation. So far we have sorted out what assets need to be probated and who will inherit those probate assets. The final portion of this discussion will focus on who is authorized to handle the probate, or to put it simply, who is going to be driving this probate train tonight. So tonight we will look at a number of items, including when somebody should and should not formally qualify as an executor, the qualification process, whether you have a will or not, and when is a surety bond required. We are pleased to have returning our guest from the prior 2 shows. He's a partner in the SURETY law firm located in Fairfax and has been in private law practice in Northern Virginia since graduating from George Washington School of Law. His practice focuses on estate planning, probate, and estate and trust administration. Please welcome back attorney David Nuhr. Hey, David.
Hi, Richard.
You have survived the first 2 shows.
That's right.
And you even came back for the 3rd one.
Glutton for punishment.
Indeed. We're going to talk about get an overview of qualifications. So tell me what is probate again? Let's get that started. Get that ball rolling.
It's a good place to start. So probate is the process of transferring over ownership of a decedent's assets to that decedent's distributees, his beneficiaries.
Okay.
Often the process will include qualification of a personal representative. That could be an executor under a will or an administrator for an intestate estate.
Okay.
And it also has to do with the actual recording of the will in the clerk's office, as well as later on the administration of that estate.
Anything you would want to recommend folks to keep in mind ahead of going to probate and trying to get qualified? Anything they should keep in mind?
So there are slight nuances to the process in the different jurisdictions in Northern Virginia, and I'm sure all over the country for that matter. So I think it is a good idea to call the probate clerk and find out kind of what the process is and what they may or may not ask. As far as really, and you can actually, the Probate Nation has done some television shows on that. So I think, you correct me if I'm wrong, Richard, but the Probate Nation's, I think, covered Loudoun County, Alexandria City, and as well as Fairfax County.
We have done some shows, and I think we'll post up kind of a direction to the YouTube channel where those shows are posted. I think it's important. I think you're right to check, not only call, but a lot of times these jurisdictions have websites that actually will give you a list of the things you need to do and how their process works. I mean, Loudoun County is very different than Fairfax County, which is very different than Prince William County, as opposed to Arlington or Alexandria. So it all has their own little different way about how they get somebody in front of them so they can get qualified. How do we know where to go, though? I mean, I just mentioned 4 or 5 jurisdictions. So how do I know whether I'm supposed to go to Prince William or Fairfax?
So we're looking at what the residence of the decedent was at the time of death.
Okay.
And so, it's not uncommon for somebody to spend some time in a nursing home or in a hospital or hospice care before their death. So that's kind of not considered in terms of factoring in what the decedent's residence was at the time of death. They'll look at their home address, where they were before they were moved to the nursing home for purposes of determining what county or city would have jurisdiction over their probate. Okay.
Well, I know that one of the initial things we first started to talk about that I always ask when people first call in, I says, is the assets that we've identified to be probated, are they less than $50,000?
Right.
Now, I do that because, there is there's no need to qualify somebody and go to probate if you have a collection of assets to be probated that's less than $50,000. Now,
what is that called, Richard?
Well, that's called it's called a small estate, and there's a statute that governs all of that. But what the important thing I think to draw to point out here is when you start to kind of assess what assets are to be probated, don't automatically assume that asset's going to be probated. Okay. Maybe it doesn't need to be probated, and you just can't tell because they won't disclose to you the fact that there's a TOD designation or whatever it might be. So, because the process to use to get assets transferred in with a small estate is you use an affidavit. It's a statutory form, very straightforward. You can go on a number of the websites for the probate offices, have a download of that particular small estate affidavit. Now, having said that, that affidavit does require someone to exercise some understanding about what should be said, because it can get a little bit complicated. But the gist of it is to identify who died and who are the designated people to receive their asset, either because of intestacy or maybe because of a will. Okay, you know, even though the will hasn't been probated, and you have to, you know, give some indication about what the asset is and what the value is. And so we see this used often with bank accounts. There might be a bank account, or we frankly see it with a stock certificate that might have a de minimis value, I mean less than $50,000. So it's a tool.
So if I'm understanding you correctly, you're saying that if the person died with less than $50,000 worth of assets, they can avoid maybe some of the stuff that is involved in a more formal probate of a larger estate under this Small Estate Act?
That is correct. And again, when we say assets, we're talking about probate assets.
Right.
That's why when we sort of begin to ask that question, how is it owned? We're trying to figure out, as we sort of divide the pot, we're looking at the totals as they start to rack up for those assets that are identified that will need to be probated. And we want to keep an eye on that. And again, don't assume, and frequently in that discussion, real estate's not part of that discussion, okay, because of the way real estate passes. Typically, you're really talking about bank accounts, you know, and it could be stocks or bonds, it could be a car, okay. So,
are there any requirements to use this small estate affidavit?
well, you can't just rush out right away. I mean, someone has to be dead for a certain number of days, and if there is a will, you know, that you have to at least put the will of record. In other words, that means that you don't qualify, but you take the original will up to the probate office and you go ahead and admit it to record at some de minimis cost, because there's no probate tax, because you're not using that will to transfer assets. Nobody qualifies. And, you know, you want to, you know, but you do want to make sure that, and if there is no will, then you simply indicate that no one needed to qualify. You know, there's no will, and so you don't have to worry about that particular part of the affidavit. Everybody who's going to receive has to sign off. Okay, so if there's 3 beneficiaries, then all 3 of them have to sign off as under the affidavit. They can designate one of them to go pick everything up, but all 3 have to sign off saying that this person can go pick up. This allows the banks to go ahead and receive the affidavit and then disperse the money, and so they're then relieved of any further responsibility. Small estate, it's a good tool, and we did a program about that, as a matter of fact. So I call that to your attention. I think it was in season 3, and I know Lisa's going to post up there. Just going to reference to that show that's available on YouTube. Let's talk about, you know, most of the situations we see involve having a will. Okay, so so who may qualify as the personal representative where there is a will?
So when there is a will, the last will and testament document, the will itself, will name an executor. That's the person that the testator, the person who created the will, is putting in charge of administrating their probate estate. Okay,
and what if the person named in the will can't serve? They're named, but they say, I can't serve, I'm sick, or I don't want to serve.
Right. So the person can sign a waiver saying that they're refusing to qualify, and that's if they're alive. Oftentimes you'll find a situation where the person that was named as executor isn't even living, in which case you can have somebody step up, either a successor executor who is named under the document, or maybe somebody who wasn't even named and is just otherwise a beneficiary of the estate will step up and get appointed as administrator.
Sure. So I guess the thing is that if somebody wants to not serve, there is actually a Supreme Court form that actually you fill out saying, I do not want to serve. Get that filled out, get it notarized, and you bring that with you to your qualification. And then at least the probate office knows that person is out of the picture. We're going to the next person in the line. If someone has died, I think you're going to have to show up with some sort of a death certificate or some indication that they're passed away.
That's correct.
As well, so we get that together. So, you know, what are the requirements as far as to serve as an executor or as an administrator? Are there any specific statutory requirements?
There are. So you have to be an adult. You have to be 18 or older.
And you wouldn't want a 16-year-old to be in charge of this whole?
I mean, it depends on the 16-year-old in some cases.
That's true.
I mean, and I guess it depends on the 25-year-old in other cases.
That's true,
right?
too.
So you know, with that being said, if a bond is required, and sometimes we're talking, and we'll get to bonding in just a moment here, but if bonding with surety is required, sometimes the person has to have good credit history so that they can actually qualify under a bond with surety. So that's a requirement as well.
Okay.
You don't have to be a Virginia resident, believe it or not. So people will name a family member and that person moves around. You know, everybody's moving all over the country these days, so that's not that uncommon, especially when somebody names a child. So you don't have to be a Virginia resident, but if you aren't a Virginia resident, you'll have to get somebody who lives in Virginia to serve as your resident agent so they can receive service of process on behalf of the estate. Okay.
Well, let's talk a little bit about the qualification process when someone died with a will. So, you know, there are, as we mentioned, those processes do vary by jurisdiction. So, for instance, Prince William County, you have a form you fill out, and then you fax it in or email to them with a copy of the will and a copy of the death certificate so they can see the person actually is dead. And if you have a will, they got a copy of the will, and then they have their information form. And then I guess they will take a look at that and probably takes a couple, 2-3 weeks. They'll get back to you and call you on the phone, go over everything, and then tell you what you might need to do or things you need to bring with you. And then at that point, they'll set up an appointment. Other jurisdictions like Fairfax, you know, it's a little bit different. You know, you need to fill out some forms, but you need to get an appointment first, and then you bring everything with you to the probate office on that date. And I think they're looking at 2 or 3 weeks out, I think, before they can see people nowadays.
An interesting kind of tidbit that goes along with this too now is ever since the pandemic, we now have certain jurisdictions that will do remote appointments. So it's another layer of nuance between the jurisdictions about which ones will accept remote appointments, which ones will not, and then the process by which you submit original documents to these jurisdictions. So just one more thing to keep in mind, I guess, as people kind of navigate this process is that is available in some jurisdictions and not in others.
I think that's important because I remember way back when we first started the Probate Nation TV show, I asked the local clerk of the court if we could do those types of remote qualifications, because we have people that are all over the country, you know, and they had to travel by plane to get here to get to an appointment and so on. And so that wasn't really available then, which is several years back, but during the pandemic and now continuing, it has really been a blessing. You know, I've had people that have been in Alabama, in California, in Arizona, that they don't need to come here, that we can get them queued up. And again, each jurisdiction has a different way of handling it. Fairfax is a very remote oriented, so they have a lot of technology that makes it to work pretty efficiently. But other jurisdictions have these things working and it works for them, and it's a blessing. So you have to check because you know, it's a lot of work to do probate qualifications remotely, and so you just need to check with the jurisdiction that you're going to go to what they require if you want to try to do that. But typically they don't want, if you live here locally, they want you to come in.
Yes,
you know,
absolutely.
But if you're out of, if you're 100 miles away or more, I think a lot of places will try to accommodate those remote qualifications. And it really is a blessing.
It is. What types of things does somebody need to bring with them to a probate appointment?
Well, it depends a bit. Assuming we're trying to probate a will, we want to bring the original will. If we have a self-proving affidavit, of course, that should be attached. If we have witnesses, subpoenas, because we don't have a self-proving affidavit, we need to bring those originals. Okay, we need an original death certificate. Don't bring a copy, that won't work. And don't bring a copy of the will. You have to have the original will. Need a photo ID. You got to have some money to be able to pay for the bills. And I would say to you that I want to just reiterate this. Be very careful about what you estimate as the value of the probate estate. There was a story from several years back of somebody who was going in to get qualified in one of the local courts here, and the estate value was $20 million so to be probated. And so they had a very, very large probate tax. You know, there was and so they, you know, they obviously didn't have $2 million, okay, and then they just didn't have $2 million. So as a result, they didn't get qualified. And so what you would want to do is just be careful. You don't necessarily know what stuff is worth. You may think it's worth certain things. Who knows? You're not even sure what the probate assets are for sure a lot of times until you actually get qualified. So, you know, be conservative in what you estimate. And then if it turns out that you need to, you have more, that'll be uncovered in the course of some of your filings with the Commissioner of Accounts, and then they'll collect the additional probate tax at that time. So, but just be careful about that. If someone's not going to qualify, you need a waiver of qualification form so we can get them off the list, so that someone else can go ahead and can serve. So I think those, and then if, like you said, if you have someone who's living out of state, then we have the resident agent that needs to have a form filled out too. So there's a bunch of little things to get. None of them are, you know, none of them involve brain surgery, but all of them are, you know, are just one more thing you got to know how to, that you need to bring it. And in some cases, you have to know how to fill it out. So,
who administers the estate pursuant to a will?
So that generally is going to be pursuant to the will is going to be either an executor who's named in the document, or if there's nobody named nobody who's named in the document can serve, then it might be an administrator. And those are people. Now the way they have authority is they actually go through the process, get in front of the court, and they actually, you know, they get sworn in when all the paperwork is complete. They got to raise their right hand or left hand, as the case may be, and get sworn in. And they sign an oath saying they're going to do certain things. At that point, they'll get what's called the Certificate of Qualification, and that's your ticket that says that you have now been conferred with the power to drive this particular probate train. Now, that can be good news and bad news, okay? But at least we know that you're the person that has the authority to sign stuff on behalf of the estate. So the Certificate of Qualification is the key. Now, tell me, let's talk a little bit about you know, surety on the bond. I think it's this part of the show. I think we had brought this up, did we not? Okay. You know, I mean, I think you know, a lot of times the will will say, if there's a written will, will say that surety on the bond is waived. And what that means is what?
So surety is insurance, basically. An insurance company is saying that the person who is qualified as the personal representative of the estate is insured for doing the job they're supposed to do, and if they don't, there's an insurance that will cover damages that were done by that personal representative.
Okay.
So to qualify, if as you said, if surety bond is not waived under the will, somebody will have to have reasonable credit in order to get bonded with surety, because the insurance company will want to know what their risks are when they're insuring this person. So if they have maybe a bankruptcy in their past, or a felony, or something like that, or poor credit, those are all things that would count against them in terms of getting bonded with surety, getting that insurance coverage.
So let's talk about, I didn't mean to jump ahead too far, and so Lisa, forgive me for doing this, but qualification with a copy of the will. How do we go about handling that?
So when you have a copy of the will, it's probably the more standard qualification process. So you're going in to the jurisdiction where the decedent passed away, and you're going to, a copy of the will. I was thinking with the original will, my pardon. So when you have a copy of the will, you need to petition the court in the jurisdiction where the decedent resided at their death to ask them to admit this copy of the will. And so sometimes that happens, right? You know, especially in this digital age, oftentimes there will be a scan or some digital copy of the will, or even just a photocopy of the will, and the original can't be found. So, you know, these things do happen, and you'd be petitioning the court, asking them to accept this copy as if it was the original of the will.
And typically, like for instance in Fairfax, you know, once you get that order entered, which typically can be entered on a Friday, you can generally walk down at that point and actually go ahead and get yourself qualified. Yeah. What if I don't have a will? Okay, so there's no will whatsoever. Tell me a little bit about the qualification process without a will. Can I just walk in, someone dies today, can I walk in tomorrow and go ahead and get qualified?
Depends on who you are, but typically not. So if you're the spouse, within 30 days you can get qualified under the statute. And again, when we're talking about somebody who's passed away without a will, we're really looking at the intestate statute in Virginia to find out who can and what can happen. So if you're a spouse or if you're a child when there is no spouse, within 30 days you can get qualified. If there are no people, no spouse or children, then it's a broader selection of people, but more time has to pass before you can qualify. And if you do qualify, they want to make sure, say you're a more distant relative, or possibly sometimes creditors of the decedent will qualify when nobody's qualified so that they can get paid out of the estate. They want to make sure that more time has passed to allow closer relatives to step up and get qualified. And they want to make sure, if you are that more distant relative, that you provide notice to everybody else and you couldn't find anybody to qualify that would be kind of higher on the pecking order than you before you qualify.
Sure. Now, we started to talk about bonding with surety, but as most states, as we move into talk again, come back to the bonding issue, whether you have, everybody's going to have to be bonded. Okay, right. So it might be that you have to give a personal bond because the requirement for surety was waived. But if surety is going to be required, a good example where it might be required is if someone's going to qualify to administer an intestate estate. Is that true?
Absolutely.
And so one of the things that you have to be careful about, of course, is you don't want to show up for a probate appointment and find out that you haven't been pre-approved for your bond if you have to have a surety bond. So you want to make sure that that T is crossed and that I is dotted before you show up. Otherwise, you could have wasted all this time to find out that they can't give you the certificate of qualification because you can't get bonded with surety. So let's talk. We're at that particular stage, though, I think, where we want to have a conversation about, kind of review and talk about, pitfalls and recommendations in connection with the qualification process. Any thoughts you want to share with us, David?
I think one thing when we're talking about, somebody qualifying with a will, which oftentimes is a much smoother situation than qualifying without a will in an intestate situation. But even within a will, there's some things that can be done if the circumstances are right, to make things even easier on the people that will be administering the estate. So if you have maybe a tight-knit family where the children all get along, it's possible for the testator to name their children both as co-executors, and then if they're also the residuary beneficiaries of the estate, meaning they're going to receive all the property, all the decedent's property as well, and equally to split it between them, then that allows them to have a quickened or an easier administration, and it waives some of the requirements for them in terms of filings that they would have to make when they're administering the probate estate.
That's a good suggestion. I would say, if I had to make one suggestion, would be if someone's going to come in for a probate consultation with an attorney, they're going to have to complete a probate questionnaire, and basically 10 or 15 pages to figure out, as we just talked about in show number 1, what assets you have, and then of course we want to know what documents you have that governs the disposition, and then we have to figure out if there's going to be any special issues regarding getting somebody qualified. So, you might want to consider, getting a hold of a probate questionnaire, even though you haven't passed away, and see if you get your estate organized so that it makes it as easy as possible for those kids who might have to qualify after you've passed away.
I think that's an excellent suggestion, because in terms of administration, beyond almost anything else, the more organized the decedent was, the easier it is on his children or whoever he's named to administer his estate to take over, or her to take over her estate. Sure. Along those lines, I think a useful tool, another recommendation I would have, is the use of what's called a tangible personal property memorandum. So this is sometimes it's referred to in the will. They'll make a reference to it in the will. And again, we talked in an earlier episode about tangible personal property being household possessions, jewelry, collectibles, artwork, all types of, your physical possessions that you own. So this wizened attorney I know, who may or may not be named Richard, once told me of an early estate plan that he had drafted where the person wanted to list out 20 pages worth of specific bequests for these tangible personal property items. And the thing that often happens with these types of bequests is that, later on you find out that the person you intended to give this to is not interested in it, or they've passed away, or you've fallen out with them and you no longer want to make that gift. And then you have to go in and do a codicil to your will, which is a huge hassle. So by using a tangible personal property memorandum, which is just a blank list where you list out on one column what the item is that you want to give away. So, grandma's gold diamond earrings. Mm-hmm. And then in the second column, who's to receive what, you can kind of avoid that whole problem.
It's a good idea, and I did draft that will, 20 pages of bequest of everything in the house from top to bottom, and it was something else. Well, look, we are out of time, and I see them waving to me behind the cameras that we need to wrap it up. So, David, thank you for coming and being with us for all 3 shows, helping us kind of walk through, some things we've seen in probate consultations that people might well expect when they have to undertake to probate some estate for a loved one. So, thanks again for this great public service.
Thanks for having me.
You bet. This brings us to the conclusion of our series of shows on the initial probate consult, from what the heck needs to be probated to who gets the money, honey, to who's in charge of this probate train ride. We hope you found all these shows helpful. Let's take a moment to review what can be learned from these 3 shows. Now, I think the first thing is keep good records and copies of asset statements and beneficiary designations so your family understands what assets need to be probate and what assets do not. Review your estate documents regularly and do a dry run of how your appointed executors can get educated in order to get your estate probated. And I frankly think it's a wonderful idea to prepare a probate questionnaire periodically as a means of collecting all this critically important information. For those of you who have a revocable trust, finally, get the assets funded into that trust. I mean, goodness gracious, that's a good thing to do. But frankly, the most important lesson to take away is this. There are many tasks to be done in the course of a probate, and you may be the right person to handle some. Yet, before you run off to court to probate a will, qualify as an executor, file tax returns, or pay creditors, stop. Pick up the phone and consult with an attorney about the probate journey you're about to be asked to navigate. That advice can save you both time and money. This brings us to the conclusion of our show. I hope you found it helpful. Until next time, take care, live wisely, and be safe out there.